Good afternoon. My name is Ben Bryant. I'm an associate at Clyde & Co. And on behalf of Dr. Allegra Shepherd, the founder and chairman of the London Shipping Law Centre and Young Maritime Professionals, Francesca Cappa, the chair of the YMP committee, and the YMP committee itself, welcome to this London Shipping Law Centre Young Maritime Professionals Global webinar series event, which is being hosted by Clyde & Co. First of all, a big thank you to both Gerard and Francesca at the YMP, and to the team at Clyde & Co for all their hard work in putting this talk together. And also a big thank you to Dr. Allegra Shepherd and the London Shipping Law Centre for continuing to provide a platform for different professions within the shipping industry to interact and to learn from one another. The title of today's webinar is Common Issues in Contract and Insolvencies. We have two speakers. Our first speaker is Andrew Bicknell. Andrew is a partner in the Marine and International Trade team at Clyde & Co. Andrew specialises in shipping and insurance litigation. He has a broad experience of marine disputes and acts principally for insurers, charterers, owners and traders. Andrew will be giving a talk on the suspension and termination of contracts with a focus on time charter parties. Our second speaker is Mark Stiggelbout. Mark is a junior tenant at Quadrant Chambers. Mark has broad international commercial practice and a particular emphasis on shipping, commodities, insurance, international arbitration, aviation, and energy disputes work. Mark's going to be talking on maritime insolvency with a focus on liens on subfreights and sub-hires. We hope you enjoy the talk. There will be questions and answers at the end. If you wish to ask a question, I think the easiest way to do so is to just put a message into the Q&A message box that you should see on your screens. So without further ado, I'm now going to pass over to Andrew.
Thank you very much, Ben, for your effusive welcome, and I would like to thank the organisers for the opportunity of speaking today. My subjects are going to be termination and suspension of contract. We'll start with termination, and this has generated more than its fair share of litigation under English law. It's when a contract comes to an end and effectively you're going nuclear, it puts a great deal of strain on the wording of the contract and the actions of the parties. And there are many pitfalls in this, and many even innocent parties breach can find that they go from being the innocent party to being the guilty party if they do not follow the correct procedure under their contracts and under common law. So, looking first at the key grounds for termination under English law, at common law, and as a remark, I'd say I know we've got a mixture of young maritime professionals. I know quite a few of you will be from law firms and P&I clubs. I'm also obviously want to pitch this so that it's right for the non-lawyers amongst you. And so when I will try and avoid as much jargon as possible, but so when I'm referring to common law, I'm referring to that element of English law which is effectively judge-made law and custom-made, where cases have been heard before the courts and created a body of reported decisions that act as precedent and are useful for the succeeding cases. So at common law, the breach of an express or implied term of the contract may entitle the innocent party to terminate. And in establishing when a right of termination occurs, you have to categorize the terms of the contract into effectively three different types. That is condition, warranty, and innominate terms. If the obligation that has been breached is a condition, the innocent party has the right to terminate the contract. That's, you know, that is their right, because a condition is a term of a contract which goes to the root of the contract. So breach of it is very serious. Examples of that in for example, a commodity contract, those are always based around shipping goods by certain dates, because that will be completely wrapped up in the payment terms and the pricing terms, etc. So if you fail to ship within the window, that is always going to be a condition of the contract, breach of which would give rise to a right to terminate. On the other hand, a warranty is a much more minor term of the contract, and if the obligation has been breached as a warranty, the innocent party simply does not have the right to terminate, even if there is a breach. I always struggle to think of clear examples which are warranties. So if you've got a charter party and it for some reason that specifies that the owner is to fly the charterer's company flag and they fail to do so, that's not going to give you a right to terminate the contract. That would simply be a warranty. But then the problem is, we've got this massive gulf between really important terms which are conditions and minor terms which are warranties. What do we do with the morass of terms in the middle? Well, English law decided to categorise that mid-term as innominate terms, and if it's an innominate term, the entitlement to terminate will depend on the seriousness of the breach that has occurred. The case cited there. This all actually, like so much of English law, stems from shipping decisions. And the key one on that was back in 1962, the Hong Kong Fur, which indeed was a charter party dispute. And briefly going through the facts of the Hong Kong Fur, just to help to explain it. Now, the breach in the Hong Kong Fur was under a long-term time charter party. The vessel was delivered into the time charter in an unseaworthy condition. Now, most people, I think, listening to this with some legal knowledge will think, well, okay, or maritime knowledge, it's pretty, it goes to the root of the contract, surely, if a vessel is unseaworthy when it's delivered. But not so in this case, because it was a long-term charter, and the faults with the vessel, though they were quite numerous, were relatively easily fixed. So the House of Lords decided that this should not be regarded as an absolute condition of it. It was an innominate term, and because the faults could be fixed relatively quickly in relation to a long-term time charter, it was insufficient to justify the termination. So the poor old innocent charterer who's been received an unseaworthy vessel didn't have the right to terminate. And that really emphasizes, I think, a lot of the points that I'm going to go on to deal with, that there's a lot of art rather than science in termination, and therefore you have to proceed prudently and cautiously. So what are the triggers? At common law, you have a renunciatory breach of contract, and this is where one party displays a clear intention not to perform and not to be bound by the contract. And to use the quote there from in my slides of the main contractual textbook chitty, quote, a renunciation of a contract occurs when one party by words or conduct evinces an intention not to perform or expressly declares that he is or will be unable to perform his obligations under the contract in some essential respect. So it's the language that is always bandied around when a party is effectively accepting a repudiatory breach of the guilty party is that they have evinced an intention not to perform or be bound by the contract. Turning then to what contracts themselves say as opposed to common law, you will have you can build in an express contractual right to terminate. And then if you then want to rely on that, the termination must meet the contractual requirements and be exercised in accordance with the contractual regime. And so you read your contract carefully and you get it right. Otherwise, as an innocent victim of a breach, you can quickly turn into the villain if you don't do it right. It's important to notice that you can't, under English law, terminate for convenience. This rather inconvenient pandemic means I can't perform my contract and therefore I'm off. That doesn't work as a matter of automatic English law. What English law does is to permit the parties build in force majeure clauses which specify circumstances where performance of the contract can be suspended, or if it goes on long enough, terminated. But those are not general concepts of law. That has to be purely a creature of the contract. The party wishing to rely on this force majeure event, which makes performance impossible, must bring themselves squarely within the words used. So it's purely contractual options which need to have been agreed by the parties under the contract. And again, just to underline how careful you have to be, we've got a case there where you've got multiple termination rights. The Funds for You Limited versus case, caution must be exercised when terminating if both the contractual and common law or competing contractual rights exist. You have to get it right when you give notice that you're going to terminate. What happened in that case was that Funds for You went into a form of insolvency, and EE triggered a clause in the contract referring to rights of termination where there was an insolvency. But they did not add into it that they were in their notice that they were also relying on material breach of the contract. And so that effectively cost them 200 million of damages, because then they were effectively deprived themselves of the right of relying on the material breach term of the contract. And they were sitting next to each other in the contract, and they just referred to one or the other. So again, if you're terminating contracts, you have to get it right. And as I've got there, termination notices must be very carefully drafted to ensure that all rights are preserved. And again, I'm rather emphasising the extent to which termination can go wrong, and I think that is the right thing to be telling you, because it means it needs to be, every case needs to be approached with circumspection. If there is a wrongful termination, if you're terminating that lawful grounds, that itself will be a repudiatory or renunciatory breach and gives the innocent party a choice. They can, they can accept the repudiation or the renunciation, which means they would treat the contract as being at an end and claim damages, or they can keep the contract alive and claim damages, going all the way back to the 61 decision of White and Carter. The limits put on this are there has to be a legitimate interest in keeping the contract alive, and that to do so would not be perverse. And that comes from the 2012, or was reiterated in the 2012 decision, the Aquafate. Now, just to expand very briefly on that, how it takes two to tango. How can a contract work where one say, no, I'm not going to be bound by its terms, the other say, I don't care what you're saying, you're bound by it, we're going to perform? Well, you can, if the ship owner under a charter party can perform the contract, they can follow the orders they were given, or they can sit idly by and collect hire. it doesn't really require the charterer to do anything. So in the Aquafaith, the charterer tried to redeliver early, and the owner said, no, I'm not having any of it. The charter continues to run. And it was decided they had a financial interest in doing so. They weren't first, and that contract persisted, and they could continue just to click over claiming their hire. Very careful also, because you can waive termination right. Care must be taken not to waive any right to terminate either expressly or by conduct. So what we've seen is there are quite a few things here which demonstrate the caution that's required. In the light of the principles set out in the previous slides, it's vital to ensure that any termination right is exercised carefully and, if applicable, in accordance with the contract. So if you're relying for termination under an express contractual right, first, ensure that the circumstances fall squarely within the clause. Secondly, follow the procedure and notice provisions of the contract. And then at the same time, consider whether common law rights exist. There is no harm in adding strings to your bow when it comes to termination. Be clear, be accurate, and make sure you're relying on precise terms. And if you're relying on precise terms, you put those in your notice. And with any form, as with any form of potential claim that's going to arbitration or litigation, retain the evidence to support right. I'm going to turn now and look more specifically at charter party cases. Non-payment of hire is obviously right up there from the ship owner's perspective as going to be asking the question, can I terminate this contract? Clearly, a charterer's failure to pay hire in accordance with the terms of the charter will put them in breach of contract, and the ship owner may claim the outstanding hire as damages and claim interest, or may prefer to terminate the charter, i.e. withdraw the vessel from the charter service, where they will want to do that where they just don't want to claim damages the charter is unable to pay. And perhaps most commonly the case which determines whether or not there is termination in hire cases is whether we're on a rising or falling market. Rising markets, I think some of us still remember those, but where you've got a rising market, you can guarantee the ship owner will be much more interested in quickly terminating the non-payment than when there is there is a falling market. They're not going to be able to rehire out the vessel at an improved rate of hire. But note, under common law, the failure to pay hire in full or on time is not usually going to be treated as a breach of condition. You remember from the outset, the breach of condition gives you the automatic right as the innocent party to treat the contract as being at an end. Payment of hire is treated as an innominate term, one of our medium range terms, as per the Hong Kong Fair. And that was determined in relatively recently in the Spa shipping case back in 2016, confirmed. So if you're just under the common law, termination of a time charter requires the owner to prove the charterer deliberately failed to pay hire and repudiated the charter, or failed to pay on numerous occasions. And so that's quite a tough thing to do. And as a consequence of that, it's invariably the case, at least I can't think I've ever seen a time charter that doesn't contain an express termination clause providing the ship owners with the right to terminate following charterer's failure to pay hire, even if the failure is unintended. and this is where you have a right to withdraw the vessel. And so, for example, the Shell Time 4 clause 9a, in default of such proper and timely payment, owners may withdraw the vessel from the service of charterers without prejudice to any other rights owners may have under the charter or otherwise. Now, it's very important to note that withdrawal is not suspension, which I'll be talking about later. Withdrawal is, again, going nuclear. It is when you withdraw from the vessel from the service, it is terminating the contract. It is bringing an end to the charter party. And so this isn't a temporary measure. And again, if you are bringing the contract to an end, English law requires a good deal of caution and circumspection. And that's the first note of caution. The second note of caution with that is that, of course, the owner of the vessel not only has contracts with his charterer, but also with cargo interests under bill of lading, their bill of lading contracts. And withdrawal under the charter does not terminate the ship owner's duties under those contracts, under the bill of lading contracts he's got with the cargo interests with cargo on board. And therefore, you can find yourself, if you are terminating in the wrong place, the ship owner isn't getting his hire from the moment of termination, but he's getting, or coming in at least, but he's still having to perform the laden voyage and deliver the cargo. So it's usually better for the ship owner to withdraw when hire remains outstanding and the vessel is not carrying cargo. And the ship owner must make the decision whether to withdraw or continue despite the breach of charter. It is an election they have. They must make up their mind which route they're going to take. Waiver and estoppel. Again, these are fragile rights which can be relatively easily lost. So you mustn't do anything that's inconsistent with the right to terminate or withdraw. So a ship owner may be stopped from claiming that the charter failed to pay hire in accordance with charter party terms if the payment followed a practice put in place by the parties. It's quite nice. I'll quickly go through this case and the one on the following slide, as they're a nice matched pair, which make the point. In the Tank Express case before the Second World War, the 7-year time charter required hire to be paid in cash in advance. But from the start of the charter, they'd got into the habit, recognised by both sides, that payment was made by cheque posted 2 days before the month end. War comes along, there's a bit of a delay in the post, and the payment is late. But the House of Lords said that the owners were stopped, prevented from relying on the withdrawal clause. The variation of the method of payment was treated as an unequivocal representation that the owners would rely on. Compare and contrast with the scap trade, where the owners accepted late payment without protest 16 out of 22 times. So I think the charterers, when the ship was withdrawn, say, "Oh, well, you can't do that." Look at that case before, when it was only a couple of days, and they've been doing this all the time. The House of Lords rejected that because what you'd got was there was no variation in the terms. The fact they'd been silently accepting late payment didn't mean they'd waived any of their right the next time the payment was late. There had been no variation of the contract, and silence alone was insufficient. The next 2 or 3 slides are on anti-technicality clauses, which I'll push relatively, so I don't overrun by too much. Often the late payment of hire results from an oversight or mistake rather than a deliberate act. And as we say, we're going nuclear there. It's the whole contract coming to an end, and it might seem therefore a bit proportionate. So the way that this is dealt with is that charter parties habitually include anti-technicality clauses as a way of giving the charterer a grace period within which to make a payment, make good their error, or face the withdrawal of the vessel. Okay. And it, as I say, it gives the charter an opportunity to remedy the failure to pay. The anti-technicality clause obliges the ship owner to give notice to the charterers of the failure to pay hire on time, and requires the charterers to pay within an agreed additional period of time, the grace period. And this has to work effectively legally. This has to be an ultimatum. Unless you pay within the period, we will the vessel from your service. And there was a very famous case where the anti-technicality notice did not contain the ultimatum, and it was ineffective, even though the ship owner had the perfect right to do it. Again, they didn't follow the rubric correctly, and they paid a heavy price for failing to do so. And of course, it means that if the charterers do pay within the grace period, then the vessel can't be withdrawn from their service, and and as we say, the ship owner must comply with the requirements of the anti-technicality clause if they wish to withdraw the vessel. And here we have, I'm not going to cite where they arise, anti-technicality clauses in contract shell time 4, clause 9a, and clause 8.4 of the P time 3. Read those as leisure, but they're very straightforward. Really, just to note this, that underpayment doesn't, a ship owner will usually not be allowed to withdraw the vessel for underpayment performance, as the anti-technicality clauses usually establish a link between the right to withdraw and higher installment. That's all relatively technical, but it's important to understand the main thing about anti-technicality clauses is they have to be used very correctly. There has to be an ultimatum, and if they're not, you're going to be in trouble. Okay, so that is my talk on termination, which is the bulk of what I've got to say to you today. Suspension is a very interesting topic under English law, but it's far less well trodden than termination, because it's traditionally not figured very highly, but is becoming more relevant, and I think that probably reflects stagnant or falling markets, because it avoids some of the pitfalls of going nuclear with a withdrawal, which, as we've seen, is termination. So, under English law, unlike civil jurisdictions such as France, where French law provides the right of suspension of performance under a contract, just, oh, we can't do it. You might get away with in France, doesn't work in England unless you've provided for it expressly with terms in your contract. We believe in the primacy of contract under English law. And therefore, suspension of performance is purely a contractual option, and it may only be invoked if it's been agreed by the parties under the contract in a similar manner to a force majeure or hardship clause. No general concept of suspension. If you want it as a right, you have to include clear words in your contract. And accordingly, the operation of suspension will turn on the contractual wording and the facts. As I say, it's traditionally, this hasn't been much used in English law contracts, but it has become more popular recently, and specifically in relation to some charter parties, where the option to suspend services following the charterer's failure to pay hire is gaining interest as an additional recourse for ship owners. And the way it works is that following late or non-payment of hire, a ship owner may prefer not to terminate the charter, but may wish to exert some pressure, some commercial pressure, on the charterer to pay by refusing to comply with the employment order unless he does so. And this gives there's a number of advantages of this to the ship owner. Unless the charter provides for it, the temporary withdrawal of services, such as the refusal to load cargo or sign bills of lading, is not permitted and would itself amount to repudiation by the ship owner. So if you want to do this, as I say, you've got to have it in your contract. And therefore, it's becoming increasingly common to include in charter parties the right for the ship owner to refuse to comply with the charterer's employment orders unless and until charterers pay hire in full and on time. And there's an example, Fine 3 clause, which I won't quote you. Read that at your leisure. Interesting, the NYP 93 clause 11 provides another useful clause for providing a right of suspension. And whereas, make the point, a withdrawal terminates the charter party, but the ship owner remains responsible for the performance of their duties under contracts. As we say, they still have to deliver cargo under a bill of lading contract. That's why withdrawal is best carried out when there's no cargo on board. But if you can exert more pressure with the suspension right, because it may permit the ship owner to refuse loading cargo and may therefore make withdrawal simpler. And again, it's a question of timing. If you're doing it when you haven't got the contract signed under the bill of lading, you're going to be able to exert a significant pressure as a ship owner using the suspension clause. And we've already done anti-technicality, which you might gain from my tenor. I find relatively boring. So such rights, I'm going to quickly run through the anti-technicality. Such rights suspension usually require the ship owner to give the charterer notice of the anti-technicality clauses. Most clauses give the ship owner the right to suspend services only after expiry of the grace period, as per any anti-technicality clause, and the ship owners must therefore comply with charterer's employment orders during the grace period, which includes orders to load the cargo. And just I will make reference to the BIMCO non-payment of hire clause. That I would say if you look at one, this is a particularly good, clear clause, and explains the notices that need to be served. And just at the bottom of that slide, I would also make reference to the NYP 2015 clause 11D, which enables owners to suspend services without needing to wait for a grace period to expire. So we've managed to get through half an hour without referring to COVID. I suppose we have to at some stage. In a COVID world of termination, from the charterer's point of view, the economic situation following COVID-19 may cause sufficient financial difficulty for charterers to impact their ability to pay for hire, and you're going to get into more termination and suspension clause situations under charter parties. At the same time, COVID-19 events may allow charterers to invoke off-hire provisions under the charter party, so that hire ceases to be payable for the period of off-hire of the off-hire event. I think what I would say in a general sense, I've had to look at COVID from the point of view of frustration of contract as well. I think English law is not going to rush to open the floodgates, but these questions have to be asked and answered increasingly, I think, over the months. From a ship owner's perspective, the parties will want to protect their respective positions, and the ship owners want to ensure a new charter party. It's just a general question of making sure that rights are protected as best you can using clear words under your contracts. Some brief concluding thoughts, as I am running slightly over. Be aware of possible changes in the law. That's just throwing in as a quick example the Insolvency Act 2020. Some of you may be aware of it. I'm not sure how commonly it's known, but this is an emergency thing, that a piece of legislation the government have put in, which gives companies that are struggling greater protection during the pandemic, and that may impact on carriage contracts such as charter parties, because there are going to be greater protection. I'm not saying there will be, but it's another thing that may come up as an issue at the moment, and may wish to be provided for, at least in short term in contracts. Don't get too fixated on COVID. As I say, I don't think the courts are going to want to open the floodgates for an express COVID problem in contract. And so don't draft too narrowly. I think rely on the standard clauses. The main thing with any contractual clause, if you want rights of termination or suspension, is to draft clearly. And as ever, try to work out which party is most likely to want to terminate, and you have clauses which protect as best they can. And finally, you try and create a balance between giving protection but not creating a regime which is open to abuse. Okay, so thank you for your attention. I rushed through those last slides a bit so as we could stay mostly on track. Thank you for listening, and I think we'll do questions at the end after Mark, who I'm delighted now to hand over, will take over.
Thank you, Andrew. I'll now bring up my slides. So hopefully you can all see my slides. Welcome everyone, and I'm going to be talking about liens and subrate and subhires, which can be a very useful tool for an owner to use in the event of the insolvency of their charterer, or even just the default of the charterer in making hire payments. Now, the first point to be aware of is that these kinds of liens are creatures of contract only. So the owner will only be able to exercise a lien if the contract with the charterer so provides. Fortunately, however, most of the standard form charter parties do provide a lien clause. Probably the most frequently encountered of these is clause 18 of the 1946 version of the NYP form. This provides that the owner shall have a lien upon all subfreights for any amounts due under this charter, including general average contributions. Notably, after much litigation, this was updated in the 1993 version of the form to say that the owner shall have a lien upon all subrates and or subhire for any amounts due under the head charter. And as we'll come on to see in subsequent slides, that is an important amendment and will make a difference if you're trying to claim from a subcharterer who has a time charter with the charterer. And in the 2015 version of the form, the wording was widened again to say that it also applies to dead freight and demurrage claims belonging or due to the charterers or any subcharterers. Now, those are all NYP clauses, but many other standard form clauses include such lien clauses. Now, what does the lien clause allow the owner to do? Well, essentially, it permits the owners to intercept freight and, depending on the wording of the clause, sometimes hire that's due to their defaulting charterers from the charterer's subcharterers, provided that the owners give notice of the exercise of the lien before the party liable to pay the freight or the subhire has done so, has paid it. So looking at that simple diagram, if the charterers are in default of their hire payments to the owners can give this notice to the subcharterers saying, don't pay the voyage charter freight or the time charter hire to the charterers, pay it directly to us, the owners. It's worth contrasting this kind of claim with a different kind of claim that the owners can have where the charterers are in default. Where the owners have issued their own bills of lading, the owners have what's marked on the diagram as a direct contractual claim under the bill of lading. So even if the bills of lading say freight payable as per charter party, if the charterers are in default, the owners can say to the shippers, don't pay the freight in the ordinary way, pay it to us, the owners. but that's a contractual claim. What's interesting about the subfreight and the subhire lien claim is that it gives the owners a direct claim, a direct right of action against the subcharterers, even though the owners have no contract with the subcharterers. Now, before we get into exactly how and why that works and why you can bring a claim against a party with whom you have no contract, there are some points the owner should be aware of before they think about exercising this right of lien. The first is that it only works if the charterers are in default. And that's because the lien is expressed to be a lien for amounts due under this charter. So that's a reference to the head charter party. The next point to note is one which raises the issue about the amendment between the 1946 and the 1993 versions of the NYPE form. Because on current High Court authority, if the lien clause only says that it's a lien over subfreights, such as the unamended 1946 form, it will not capture hire if the subcharter happens to be a time charter. And that's now fairly well established at High Court level, most recently in the bulk Chile, although interestingly, in that case, Mr. Justice Andrew Smith said that he would have preferred the view that subfreights was wide enough to include subhires under a time charter, but because the point had been considered in very great detail by Mr. Justice Steyn in SEBI number 2, he wasn't prepared to depart from that earlier view. So there may be a challenge to that rule in the Court of Appeal, but at the moment it's established at High Court level that a lien over subfreights will not allow you to claim hire from subcharterers. Now, the next point to be aware of is that this kind of lien claim will only work if the owners give notice of the lien before the freight, or in an appropriate case, the hire is paid by the subcharterers to the charterers, because otherwise the lien simply fails to bite on anything. But on the flip side, it will bite on freight which falls due after the notice is given. So in the bulk Chile, for example, the owners gave a notice of lien 2 days before the freight actually became payable to the charterers under the subcharter. And it was held that the lien claim was nonetheless valid, and it captured the freight which became due 2 days later. It therefore seems sensible, based on those latter 2 bullet points, to give your notice of lien as soon as possible as an owner, because if you give it too late and the freight or subhire has already been paid, you won't have the claim anymore. And if your notice happens to be a few days early, it should still work to capture that subsequently accruing freight or hire. And a final initial point to be aware of is that it's currently unclear on the authorities whether amount due under the head charter includes damages claims. Now, ordinarily that won't matter too much because the head owner's claim will normally be for unpaid hire by the charterers. But in the Western Moscow, the owners also said that they had a claim for damages for repudiatory breach. And it wasn't necessary for that to be decided in the case, so that point has been left open for future cases. Now, what's also very useful for an owner is that the lien works also to give you claims not only against subcharterers, but against sub-subcharterers. So we've seen in previous slides that the owners can give this notice, and that allows them to bring a direct claim against the subcharterers. But the owners can also give this second notice to claim voyage charter freight, for example, under a sub-charter. And that's provided that you have a lien clause in the top 2 of the 3 charters. You don't need to have a lien clause in the 3rd one for that to work. But it's worth bearing in mind the point made in time charters that this will only be possible if there is a debt outstanding at each link in the chain. Now, the nature of the lien has been subject to considerable discussion, both in the cases and academically. But the view which has become accepted, at least again at High Court level, is that the lien operates through an equitable assignment by the charterers of the subcharter debt by way of security constituting some form of equitable charge for the charterer's debt under the head charter. So if you look at that diagram to the right-hand side, the analysis is that the charterers say to the owners, in order to secure our future debts to you in terms of hire, we'll grant you an assignment of any voyage charter freight that we're entitled to, either now or in the future. Now, the cases have also established that this lien constitutes, or at least resembles, a floating charge over the charterer's book debts, which crystallizes by the owner's notice and furnishes a proprietary right in equity. And what that is saying is that so long as the charterers are not in default to the owners, the charterers can continue to collect their voyage charter freight or their subcharter hire in the ordinary course of business. But if they fall into default, the owners can give that notice, and at that point there's a crystallization, and the owners have a right to claim the debts themselves directly from the subcharterers. And this is the way it was analysed by Mr. Justice Christopher Clark in the Western Moscow. He said, "I do not see why the clause cannot be regarded as amounting to an agreement to assign future debts by way of security, which gives rise to rights in equity. Although the lien provides an immediate security interest at the date of the charter," so that's the head charter, "it may be that it creates no proprietary interest in favour of the owner until the owner gives notice, because until then it is open to the charterer to claim the debt in the ordinary course of business." So on that analysis, at the time the head charter is entered into between the owners and the charterers, the owners do have an immediate security interest, but it's not actually one that creates a proprietary interest in the owner until the owner gives notice once the charterer falls into default subsequently. Now, Mr. Justice Christopher Clark also explained why it is that the equitable charge analysis works in a 3 charter party scenario, and he explained it by way of a chain of equitable assignments. So the subcharterers equitably assign their rights against the subcharterers to the charterers, and then the charterers can assign those rights that they've received to the owners. And that's the way it was put in the Western Moscow by Mr. Justice Christopher Clark. I've put the letters that he's referring to on the diagram on the right-hand side. Essentially, he starts with Party A, and he says, Party A says that it will assign its rights against D to Party B by way of security. And then Party B says to the owners that it will assign not only its pre-existing rights against Party A, but also its rights that it's just received against Party D. And it will assign both those to the owners. So that's why the owners have claims against A and D. Now, in the Western Moscow, Mr. Justice Christopher Clark declined to follow a different analysis of why the lien clause works that was set up by Lord Millett Obiter in Agnew. And Lord Millett had said that this is not actually an equitable assignment, and it doesn't give you an equitable proprietary right. Rather, he said it was analogous to an unpaid seller's right of stoppage in transitu. And what that means is if a seller of goods finds out that the buyer is insolvent, the seller can give notice to the carrier to stop the goods and not deliver them to the buyer. But Christopher Clark said that this can't be right in his view, because that would not explain why the owners would have a direct claim against the subcharterers, as opposed to a right to get an injunction stopping the charterers from collecting the lien debt themselves. And there were several High Court cases in the 1980s which actually decided that point, that it's not simply a right to an injunction against the charterers, it's actually a right to bring a direct claim against the subcharterers. Now, one interesting implication of this equitable charge analysis is that for charterers who are incorporated in the UK, the lien clauses, because they're equitable charges, will be registerable under the Companies Act 2006. And the Companies Act says that if you fail to register an equitable charge, the charge will be void so far as any security on the company's property or undertaking is concerned against a liquidator, an administrator, or a creditor of the company. Now, in the textbook Time Charters, the point is made that this won't necessarily be a great problem in many cases, because it will be relatively rare that you have charterers who are incorporated in the UK. But it doesn't point out that there may be similar legislation in other countries which has the same effect. So there was this case in Singapore in 2017, the Duncan and Diablo Fortune case, which concerned charterers who were incorporated in Singapore. And the Singaporean liquidator sought a declaration pursuant to that equivalent of the Companies Act legislation that the Clause 18 Bearcon lien was void against them for want of registration. And the High Court of Singapore upheld the liquidator's application. They endorsed the equitable charge analysis of such liens, so they agreed with Christopher Clark's view in the Western Moscow rather than Lord Millett's view in Agnew. They said it's therefore an equitable charge, and whilst it may be inconvenient for an owner to register a charge that's a clause in a time charter party, that's what the legislation requires. And therefore, in that case, the owner's claim to the sub-charter debts had no priority, and the same for the owner's claim when they tried to exercise a lien over the charterer's bills of lading freight. So it may be wise in long-term charters where this issue could arise for the owners to seek registration of the charge that they've created by virtue of the lien clause. Having said all that, it's my understanding that in Singapore, very shortly after this decision, the legislature decided to intervene and passed new legislation to say that whilst this kind of lien clause does create an equitable charge, it is exempt from the requirement to register such charges. And that was because they wanted to maintain the attractiveness of Singapore as a legal and maritime hub. The other set of interesting implications that seems to arise from the equitable charge analysis is that it's not clear in the authorities whether this equitable charge is a simple charge or a mortgage, because often the term charge is used very loosely in the cases. The basic distinction between the two is that a mortgage is where the debtor assigns the whole of an asset in order to secure a debt. So for example, if I owe you a debt of £100 and I have an asset worth £200, I can mortgage the whole of that asset to you, and I'll be entitled to that asset back after I've discharged my debt. But the other thing you could do in a similar situation is create a simple charge whereby the debtor does not assign the whole of the asset, but rather creates a charge over it, which is sufficient in size to secure the smaller debt owed. So in the same example, if I owe you £100, but I have an asset worth £200, I can grant a charge worth £100 over the asset. And where this is potentially important in the liens on subfreights and subhires scenario is in a situation like this on the right-hand side, where I've set out a series of debts that could be due at various links in the charter chain. Now, what we know for sure is that the owners can lien this 50,000 that's due from the subcharterers to the charterers by giving notice 1 to the subcharterers. And there's no issue there because the 50,000 is less than the 200,000 that the charterers owe to the owners. But how much can the owners lien from the subcharterers by giving this second notice, notice 2? Can they lien the whole 75,000, Or are they constrained to lien only 50,000 on the basis that the subcharterers themselves only owe 50,000 to the charterers? Now, if the lien operates by way of simple charge, the analysis would be that the subcharterers only ever assigned enough of the 75,000 to secure their own debt. So they would have simply created a charge worth 50,000 over the 75,000 debt. And that would mean that only 50,000 of the 75,000 can be passed up to the charterers and then to the owners. So that would mean the owners could claim 50,000 under notice 1 and only another 50,000 under notice 2. So they'd have $100,000 in total lien claims. But if, on the other hand, the correct analysis is that there is an equitable charge by way of mortgage, then what the subcharterers did to secure their debt of 50,000 was assign the whole right to receive freight against the subcharterers. So that would allow the 75,000 to be assigned to the charterers, and then the charterers could assign that 75,000 again to the owners. And that would mean the owners can claim 50,000 under notice 1 and 75,000 under notice 2. And that would give them a total lien claim of $125,000. So 25,000 more than on a simple charge analysis. And on this slide, I've set out the same diagram, but just with the yellow box to focus in on where this extra 25,000 is coming from and at whose expense. And you can see that it's at the expense of the subcharterers, because the subcharterers on this mortgage analysis have said to the charterers, to secure our debt of 50,000 to you, we'll mortgage our right to 75,000 against the subcharterers. So it must be that the subcharterers would have a claim, at least against the charterers, for that excess 25,000, because they never owed any more than 50,000. But that right to claim against the charterers might be not very useful if the charterers are insolvent, which is often the case in these lien cases. And there are conflicting dicta in the cases as to which analysis might be right. In a case called the SEVU number 1, Mr. Justice Lloyd gave an analysis which seems to me to support the mortgage analysis, because he suggested that what is transferred is the whole right to receive the freight due. So in the yellow box, what was transferred was from the subcharterers to the charterers was the whole right to receive voyage charter freight, and therefore the $75,000. But in a different case, the Ugland trailer, Mr. Justice Norse gave an analysis which seems to support a more limited assignment, and therefore the simple charge view. He said that the lien clause's effect is to give the ship owner a limited right to require payment from the shipper of money which is owed by the shipper to the charterer. So on that analysis in the yellow box again, what the subcharterers would have said to the charterers is, we will give you a charge over the voyage charter freight that's sufficient in size to cover whatever we may owe to you, the charterers. So in this example, it would only be 50,000 of the 75,000. And it seems to me, as a matter of principle, that this must be a question of construction of the lien clause itself, because these are simply creatures of contracts, these liens. But as we saw from the wording of the liens, that they say nothing about charges at all, let alone whether they are simple charges or equitable mortgages. So it seems to me that this is an interesting area for future exploration in the cases. And that's all I have to say about liens on subfreights and subhires. And I understand that Andrew and I are now able to take any questions if anyone has any. Thank you very much.
And of course, I would add that if anybody wishes to take anything offline and add in, I'm sure you'll be able to find our contact details if you wish just to ping an email.
So there are a couple of questions. One is if the recorded version of the talk will be circulated afterwards. My understanding is that it will be made available on the YMP's YouTube platform for viewing afterwards. And there's another question in relation to the slides. Will they be available to download after the seminar? I'm happy for my slides to be made available.
Yep, likewise. Okay, well, thank you very much to everyone concerned. I thought that was an interesting event, and the technology held up.